All rise.
Please be seated. Good afternoon. Welcome to the afternoon session of the March 7th docket for the Kansas Court of Appeals. We have two cases on the docket this afternoon. And for those of you that weren't here this morning, I'll go ahead and do introductions again. My name is Angela Coble. I'm one of the newest judges on the Court of Appeals, having been sworn in last spring. To the right of me is Judge Stephen Hill. Judge Hill served 22 years as a district judge before joining our court in 2003. So this makes Judge Hill the longest serving law trained judge in our state. To my left is Judge Gordon Atchison. Judge Atchison joined our court in 2010 after a 29-year career as a litigator. So I'm honored to sit with both of these distinguished jurists, and the three of us make up the panel hearing your cases today. So just a little bit of housekeeping. Can everyone hear okay? Microphones are good. YouTube is going. Okay. We've read all your briefs. We've reviewed the record on appeal. So we're familiar with the facts of the case and the issues presented. So just remember that as you're presenting your arguments. But with that said, I know we have people in the audience here and virtually who are not as familiar with the facts of your case. So if appellant's counsel could just take a minute at the beginning of your argument to give us just a brief summary of how we got here today. I'll start your argument timing after that factual introduction. As the presiding judge, I'll also act as the timekeeper. So if you see me glancing at my phone, it's not because I'm distracted, just trying to keep us on track. And each side will get 15 minutes of argument. Appellant can let me know at the beginning if you would like to reserve time for rebuttal. So after you present your arguments, the case is considered submitted for decision. We'll then take the case under advisement and issue a written decision as soon as possible. So with that, I will call our first case of the afternoon. That is case number 125088, Jill Foster-Koch et al. Versus the Shawnee County Health Department. If I could get appearances for the Shawnee County Health Department, please.
The court, Ashley Biegert appears on behalf of the Shawnee County Board of County Commissioners doing business as the Shawnee County Health Department.
Thank you. And for the
James Krause, Shawnee County Councilors also was on the brief.
thank you. And for the appellees.
May it please the court, Your Honor, Rebecca Phelps Davis appears on behalf of all of the appellants.
Okay, thank you. Okay, we'll go ahead and get started. Would you like to reserve any time for rebuttal?
Yes, please. May I reserve 3 minutes? May it please the court. Each one of these matters arise out of KSA 65-129C challenges to quarantine orders that were issued to 4 children in Shawnee County due to their exposures to COVID-19 in 2021. All 4 of these matters were consolidated into one case. They all contain the same legal question and analysis, but each of them are factually somewhat different. I will go ahead and recite some of the most crucial facts in this case. First of all, at the beginning of the 2021 school year, Shawnee County Health Officer Dr. Aaron Locke issued a set of guidelines to all of the school districts in Shawnee County that she composed along with several local, state, and federal resources that set forth what COVID-19 is and also the quarantine and isolation prescribed periods within those guidelines. She issued those guidelines to the school districts along with her quarantine orders and isolation orders. And each of these orders had, of course, blanks in them for the schools to fill in the demographic information of their students and teachers who were exposed to COVID-19, as well as the specific dates of the quarantine periods for each of them in conjunction with the guidelines she set forth. At all relevant times, the schools in Shawnee County were identifying COVID-19 positive cases within their walls as well as those contacts. They were doing this and had been doing this for all contagious and infectious diseases up until this point. At all relevant times, also, the Shawnee County Health Department had an employee whose sole purpose was to serve as a liaison to these schools to answer questions about the COVID-19 guidelines, isolation and quarantine. And Dr. Locke herself met with the schools at least on a weekly basis. Generally, she was in contact with them more often than that. Dr. Erin Locke provided the only medical testimony in these evidentiary hearings related to the means of transmission of COVID-19, the degree of contagion, and the degree of public exposure. No, there was no other witnesses or evidence to contest her testimony on these facts. With regard to the quarantine orders themselves that were specifically ordered in these cases, their factual scenarios differ somewhat. There were 2 Koch children who received quarantine orders. They were exposed to COVID in August of 2021. In both of the girls' cases, the schools did the contact tracing and the school nurse input the demographic information and quarantine period into Dr. Locke's quarantine order and then handed those orders to the mother of the children.
Before we get too deep into this, the quarantine orders themselves in all of these cases have long since expired.
Correct.
Okay. Why? And the parties acknowledged in the district court that rendered the cases moot. What is the pressing need for us to do anything at this point, since the orders are not in effect?
Well, the appellant or respondent at the district court, we did argue that each of these matters were moot. That was overruled by the district court judge, and she denied our motion to render each of these moot. We believe they are moot. By the time these evidentiary hearings took place, every single one of these quarantine orders had expired. However,
Your view, we should dismiss the appeal? Was that your preferred disposition?
that would be the preferred disposition. At the very least, we would ask that the court reverse the district court's finding that the orders were void and remand that back to the court to determine whether or not they were medically reasonable or necessary, which the district court in every single one of these cases failed to do. She didn't even touch the medical necessity or reasonableness of any of the orders, which is what she's specifically required to do.
Counsel, you can't have it both ways. You can't say, let's dismiss it because it's moot, and also because the district court was wrong. I mean, if you want us to say that the district court was wrong, we can't find it's moot.
Certainly.
We won't give you an advisory opinion.
Well, I think our primary goal would be to have the cases dismissed as moot, as argued in our brief. In the alternative, if the court finds that the appellee's argument withstands a dismissal based on mootness, then we would ask that the court at the very least find that the judge's order should be reversed.
You mentioned 65-129C, but doesn't that skip over 65-129B that also is relevant here?
It does, but I think 65-129C sets forth specifically what the district court judge was tasked with finding in each of these cases.
Well, but that statute presupposes an otherwise valid quarantine order.
Well, I think 65-129B lays forth the requirements for the local health officer to determine whether or not an isolation or quarantine order should be issued.
Well, and isn't that the fundamental question as to whether the health officer actually issued these orders?
That's what the plaintiffs and the would ask the court to find. But I would submit to you that in every single one of these cases, the local health officer did issue a quarantine order.
I mean, you just started describing with the Koch children. What happened was there was an order signed in blank with a facsimile signature the nurse finds that the kids met the quarantine guidelines, filled in the order and handed it to the parents or some responsible adult. The health officer had nothing to do with issuing that order.
The health officer set forth all of the guidelines and the prescribed period for isolation and quarantine. No one at the school was doing that. And you're correct
I
that the
understand that.
nurses absolutely filled in the demographic information in the quarantine periods based on their contact tracing. However,
No, wait, I don't want to, however, at this
Sure.
point, I want to ask a question. Under 65-129B, the authority of the health officer in that situation is that the health officer may issue an order requiring the individual to quarantine. It's permissive and it requires a discretionary determination, doesn't it?
yes. And
Well, and the health officer made no discretionary determination in that circumstance. If the school nurse said, you meet these guidelines, filled it out and handed it to the parent. How does that comport with the statute?
well, whether or not the health officer at the outset determined that this particular individual needed to be quarantined, she did ratify in all of these cases that under all
That's not,
the
the
set of
statute doesn't say
circumstances.
that. The statute says what it says. And it says the health officer may issue the quarantine order, not ratify it when it's done by somebody else or delegate the authority to somebody else. It doesn't say that, does it?
It doesn't specifically say that, no, but the
No.
health officer,
So, I mean, this seems to me a very simple, straightforward statutory interpretation case. And why doesn't the statute, I mean, it doesn't allow what you just described.
it's our argument that the health officer did create the quarantine order. She did determine that under a very specific set of circumstances,
And
this,
she has the discretionary authority if somebody meets the criteria to either issue a quarantine order or not. That's what the may is. She may do it. She doesn't have to. There might be exceptional reasons why she wouldn't in some case with some kind of disease or quarantine. And that's completely missing in the process you described. Right?
I think that she made a very specific, she set forth a very specific outline for under all of the circumstance under which the quarantine orders should be issued. And I understand what 65-129B states, but all of the appeals were submitted under 65-129C. And in that case, whether or not the quarantine order was issued correctly or ratified, the sole question for the court to determine is whether or not they're medically reasonable or necessary. And that was not done at all. The court never even
How's
touched that
that the only
determination,
question in front of it?
because that is the statutory framework for 65-129C for which all of these appeals were filed.
Is that authority that you speak of with Judge Atchison, is that delegable?
The authority, which authority to issue
The
the quarantine order?
Saying, student, you're quarantined.
Mhm.
Is that delegable?
For that particular student, I think
No, for any. I want to know if that's your argument, that the health officer had the right to delegate that authority to the school official.
she had a right to delegate she came up with the quarantine order herself. And then she gave that order and all of the facts and circumstances for when those orders should be issued, and then delegated the authority essentially for the schools and the school nurses to do what they're already statutorily required to do, which is contact trace and identify cases, and then fill out the form and submit them to the students. So I do think,
So your answer is yes.
yes. I do think it is important to note that for each one of these cases, the Shawnee County local health officer did ratify the decision to quarantine each of the individuals. The district court and the appellee would make it make you believe that she had no idea of the facts and circumstances related to any of these at any point in time. And she did in real time. And she also did at the hearings in each of these matters. She testified that she was made aware of the facts and circumstances related to them. And she determined that they needed to be issued, that these children needed to be quarantined. And in fact, in 3 out of the 4 cases, she ordered that these orders be served by law enforcement. Case law is clear that when an individual has the power or authority to do something at the outset, they have the ability to ratify them, even if it was done defectively in the first place. I would note that just because you find that, if you were to find that the method by which the orders were issued was incorrect, the proper remedy in these cases is not to void them completely, but to protect the public health and find whether or not they were in fact medically reasonable or necessary.
No, but that gets back to the question I was asking earlier is 65-129C presupposes that it was a valid order to begin with.
I think I have to disagree that I think 65.
It's an invalid order. I mean, like I could go issue a quarantine order, and if it was reasonable and proper, it should be upheld, even though I had no authority whatsoever to do it.
But I think that you would have to consider the fact that no, I mean, there's the schools have the responsibility to exclude you. I mean, I don't know whether in your hypothetical
their
you would,
ability to exclude is to expel somebody from school, not to quarantine.
But
Those
they
are
are-
2 different things.
they're required to expel someone from school based on the prescribed quarantine or isolation period. They have to know
I
what that
understand, but
period
that's
is.
different. Expelling somebody from school is different than issuing a quarantine order.
We have 1 minute, council.
Correct. It is different than issuing the quarantine order, but
Well, so it's not the same thing. I mean, they have the authority to expel a student. They don't have the question is whether they would have the authority to fill out an order signed in blank to quarantine somebody.
but I think the way you have to consider the statutory framework, they have the ability to
That's what I'm
exclude.
trying to do. Your gripe, I think, is with the state legislature, not with us or with Judge Watson in this case.
Well,
I guess that's not a question, it's just a comment, but it seems, again, I would go back to, this seems to be a very straightforward statutory interpretation issue. And I'm having a hard time seeing how I can get to where you want me to be.
I agree that it's a statutory interpretation issue, and that the statute specifically requires that in these cases, a statute that's designed to protect the public health, the district court judge is required to determine whether or not the orders were medically necessary and reasonable, and the court simply failed to do that in every single one of these cases. And whether or not the
We're talking in
process,
circles, so it has to be a valid order to begin with to even get to that
I
question.
think if the process by which the orders were issued is in question, that's a different kind of case. I think the process by which the orders were issued, that's a Chapter 60 case for an injunction to stop that process from happening. The 65-129C cases are specific to whether or not the orders were medically necessary or reasonable. That's our main argument, in addition to the argument that in each and every one of these cases, Dr. Locke herself did ratify and had the authority to do that. And with that, I would answer any other questions.
Okay. We'll hear from the police.
Good afternoon, Your Honors. As has been alluded to in the arguments before, the question before the court is whether the quarantine orders issued in these matters were legally issued. I do not think that you can look at 65-129C and what authority is under that and dealing with what had to be done in order to appeal.
Are you asking us for an advisory opinion?
No, we're not,
Why not?
because
These orders have expired. We can say yes, or we can say no. it'll have no practical effect on anything, will it?
It will have a practical effect, Your Honor. The matters at issue are not moot because they are,
Those orders are done.
but they're capable of repetition and they're capable
Only
of
on those
raising.
two children or the children.
Overall, they're capable of repetition because the statutory authority under 65, the statutory 65 scheme can be used at any time there is a contagious disease such as COVID-19. So it is very much capable of being repeated in the future under this same statutory scheme where the local health officer would do what happened here and not follow what is required by statute and make a determination to begin with that it's medically necessary or reasonable to issue the quarantine order.
Did the court, your opposing counsel raises the issue that the district court failed to determine whether these orders were medically necessary.
Your Honor, our position is you can't do that without looking at whether it was valid to begin
Are
with.
you saying that question is not relevant even though the statute requires that?
I'm saying that the district court did do that. They looked at
What testimony did the court refer to in her order?
the fact that the local health officer did not personally make a determination of it being medically necessary or reasonable to have the orders issued, because that sets off
So the ratification
does not,
was ignored by the court.
must be ignored.
Was the ratification evidence ignored by the court?
It wasn't
We're not
ignored.
going to pay any attention to that because you followed the wrong procedure. Is that
You can't-
what the court's order
ratification-
was?
Well, I wouldn't say that's what the court's order was. I would say that the court was looking at what the local health officer has to do to begin with, that then makes it so that you then get to
But
the
the
point where you
statute
appeal.
reviewing that gives her the authority to review that says you've got to make this decision too on medical evidence and testimony, right?
Correct.
And I don't see any of that in there. She relied basically on this claimed procedural error.
No, she didn't only rely on that. She relied basically on the testimony of the local health officer, which made it clear that she didn't know anything about what was going on until after the orders were issued. And it became an issue with these particular parents because they were upset that the quarantine orders had been issued. That's when she became aware of what was going on here. She did not do anything to make a determination to begin with of whether these orders should be issued. She didn't.
Did the district court make findings that this was not medically necessary?
No, Your Honor. There was no finding of that because the court looked at whether the order was to begin with valid.
The
Which
court
is
looked at the
necessary.
procedures. It didn't
Correct.
look at the substance.
Is it your position that under the statute, the local health officer has to do the contact tracing personally?
Our position is, Your Honor, that in order for her to know whether it's medically necessary and reasonable, she has to be involved at the beginning. She has to know what's going on.
I asked. I mean, she has to be involved in the issuance of the order. Does she have to actually literally physically do the contact tracing herself?
I believe that she does because that's part of looking at and assessing the child or the individual to see if if it's medically necessary and reasonable to issue a quarantine order.
But didn't she create the parameters that were applied? I mean, didn't she do that at the outset, create those parameters so that the schools could apply them?
She created parameters and gave it to individuals that don't have the medical background and don't have the statutory authority to be making determinations as to whether quarantine orders should be issued.
Counsel, that
She only
doesn't
has
seem to be
that.
very workable to me. One person, and you've got 10,000 COVID cases, and you got one person doing all the contact tracing.
The very nature of this statute was put in place to deal with contagious diseases and or
You need to
infections.
answer my question.
And so I
How is that
believe that,
workable? One person doing all of this contact tracing,
well, there,
you'll never get it done.
it also authorizes the Secretary of the Kansas Department of Health and Environment to do that, so they could work in conjunction to get what is required of them to do under the statute.
But we have to deal with the statute that we've got in front of us. I mean, it's not maybe.
No, I'm saying, Your Honor, under this statute, those two could work in conjunction to get the work done that is required of them. And the authority that's only been given to them under this statute. It hasn't been given to anybody else.
Is
And the
that a
reason is,
reasonable interpretation of the statutory language?
is it what, Your Honor? I'm
A
sorry.
reasonable interpretation of the statutory language?
I
What's
believe-
your- I mean, that seems kind of way out there to me.
I believe it is a reasonable interpretation, and I believe the reason that it was done and written the way it was by the legislature is because it takes away a liberty interest of the individual once the quarantine order is issued, because they are not able to leave their houses
Well,
under
I
house
understand
arrest.
the effect of it. I mean, that was the point I was making about it, how it's different than an expulsion order. But I failed to see why either the secretary or a local health officer can't rely on data compiled by someone else under their direction. And that's what you're saying. And that just seems totally unreasonable. And the statute isn't clear that that's how it's supposed to be done. I mean, it doesn't say that the officers shall investigate. It says that they're to issue the order.
So under the statutory scheme, under 65, it gives the school nurses in the schools the ability to determine who they think are either contacts or suffering from the infection. That then should turn to the local health officer once she's been informed that we think that we've got these people over here. So she or he should go assess that individual then in order to make the medical determination and whether it's reasonable to issue the quarantine order. They have the authority to say, we think this person is a contact, been in contact with a person that's infected. The local health officer then's authority and only has the authority to then come and say, I think you're right. I think that it's medically necessary and reasonable to give this person a quarantine order.
Based on the information that you as the school nurse are providing me about
Correct.
whether they were in contact with somebody else.
Correct. So that's the way, Your Honor, answering your question, they should be utilized because they have authority under the other statutes under this statutory scheme. But it should not take the place of what only the local health officer or the Secretary of the Kansas Department of Health and Environment has the authority to do under the statute. That's what happened here, is that they let individuals without the authority do what is only authorized by them to do under the statute when they're not authorized to delegate that duty to anybody. And then they had them issuing quarantine orders that then places these people under house arrest. And also part of the statutory scheme is that they can be arrested if they violate the quarantine order. And in fact, in two of these occasions that is before this court, she used the sheriff's officers to issue another quarantine order, which the testimony was she didn't know who filled that out, but it was issued, a second one issued, really to be as a threat to one of the parents in this matter, because she was as upset as she was. That should not have been done. And so, yes, use the school.
Is that in the record?
Yes, it is, Your
Is
Honor.
any of that in the record?
Yes, it is, Your Honor. It's part of the testimony.
Part of it.
Yes. And so what should have been done is use the school officials to do what is authorized by them under the statutory scheme to do, and then get yourself over there to make the assessment of the child to make to be able to determine whether it's medically necessary and reasonable to issue the quarantine order. And what the district court understood by the testimony that was presented is that that was not done. And therefore, these orders are void because they were not done lawfully. And so we would ask, Your Honors, that you do not overturn the district court's rulings because it was made after receiving competent testimony. Substantial competent evidence that was heard by the district court. And so that the quarantine orders were illegally issued and as a matter of law are void. And so they should not stand. They should be vacated as they were by the district court.
These
Void
orders that are
already.
void now.
They ran out already.
But-
I mean, we
right.
can't void them.
Yes, but again, these are not moot issues because they're capable of repetition and because these are matters of public concern.
Well, and that would be the ruling. It wouldn't have anything to do with this
Correct.
particular order. mean,
I
they're
agree.
long gone.
Absolutely. These are
Okay.
not moot. These issues are not moot because they're matters of public concern and capable of repetition. And so State versus Bennett is the case that dealt with that issue. And these cases fall under both of those exceptions to the mootness doctrine. And so we would ask that you uphold the district court's ruling. Thank you.
Just briefly, the testimony in the record is clear that Dr. Locke reviewed the facts and circumstances of every single one of these quarantine orders, agreed they needed to be issued, and reissued them or issued them at the outset. I just want to clarify that.
Was there any medical testimony to the contrary?
No, there was no medical testimony whatsoever about the medical necessity or reasonableness of these orders. None whatsoever. Additionally, to the extent these cases are not rendered moot, the district court order sets a dangerous precedent because the district court did in fact rule that the Shawnee County Health Officer cannot rely on contact tracing and case investigation information from the schools. You have to consider the statutory framework allows the health officer to in fact do that. And if she is not able to do that, and she does in fact have to assess physically each and every one of these individuals, she cannot meet her statutory duties to protect the public health in any case of infectious or contagious disease. And I would just like your honors to please keep that in mind. I'll stand for any additional questions at this point. Thank you.
Yeah. Okay, we'll consider the case submitted for decision and endeavor to get a written opinion out as soon as possible. Thank you. Okay, we'll go ahead and call our second case this afternoon. Case number 124252, State of Kansas versus Michael Alexander Hormell. If I could get appearances, please, for the appellant, Michael Hormell. Okay. And for the state.
Please, the court, your honors, the state appears by Douglas County Assistant District Attorney Brian Dyer.
And Mr. Meharry, would you like to reserve time for rebuttal?
3 minutes.
Okay. Proceed.
May it please the court, Peter Meharry from Michael Hormell. As far as a quick factual background, this case arises out of what we often call a drug deal gone wrong back in January of 2018. My client was eventually charged with 1 count of aggravated robbery, 1 count of conspiracy to commit aggravated robbery, and attempted first-degree murder. After a few twists and turns, it went to trial in April of 2021. After it was submitted to the jury, they came back with a verdict for guilty on aggravated robbery, not guilty on conspiracy to commit aggravated robbery, and then convicted of the lesser attempted voluntary manslaughter based upon the theory of imperfect self-defense.
Counsel, I think we're familiar with the facts of it. There was a mistrial involved in the first trial,
Correct.
correct? And I was always under the impression that jeopardy attached is when the first witness, the jury is called and sworn, and the first witness is called and sworn and ready to testify, and then jeopardy attached. Am I incorrect in that?
Your Honor, I will say you are incorrect on that. Jeopardy attaches when the jury is sworn in. I
From
think
that
there is,
point on,
from that point on, Your Honor. I think it's a different rule if it's a bench trial, but here we obviously had a jury trial. And once the jury was sworn in, jeopardy attached to my client. And that's why we believe that the subsequent trial was in violation of my client's double jeopardy rights, because that mistrial ordered by the court was improper. Jeopardy had attached. The reason, the problem here was that the state in its peremptory challenges discriminated against a juror based upon that juror's race. And unfortunately, the district court took objections and Batson challenges after the jury was sworn in here. That mistake doesn't mean the state gets to retry my client. When the jury was sworn in, jeopardy attached. And the reason for the mistrial was because at that point, the state had struck a juror because of race. We had a sworn in jury, a juror, who, as I said, was discriminated against, who should not have been struck. The district court did not believe they could move forward. That may be the case. Maybe, I know defense counsel floated the idea that maybe we swap the juror in. Frankly, I don't know that you can do that. I'd be somewhat dubious. So we are stuck, but we are stuck there because of the state's actions here. And that should not rise to the level of manifest necessity to allow for the retrial of my client. They had their shot and they made the mistake of discriminating against a juror. They don't get to come back and do it again because they did that.
Well, it seems to me there's a confluence. I think that was the word that Judge Huff may have used here.
Yes.
And I don't want to turn this into a tort question, but you have the misconduct on the part of the prosecutor in striking the juror based on race. And Judge Huff made that finding, and that's, whether that's right or wrong is not in front of us. I mean, it was wrong and it was misconduct. But the confluence and the compounding factor is that you have the jury coordinator or the bailiff immediately then innocently swearing in the jury when the jury should not have been, and the judge didn't direct it. It's those two together. And I'm not sure I see how the combination there isn't a manifest injustice under the circumstances.
I don't believe it's manifest injustice because still the triggering event is the state's misconduct. And furthermore, even if the jury coordinator jumped the gun, the district court failed to say, stop, wait, we got to take Batson up here. That's still not on my client. Manifest injustice is purportedly a very high standard. The burden's on the state to prove it. And here, to get around that, you can't allow the state to start the ball rolling with their misconduct. And then when it gets to a point where we can't go forward, say, well, I guess we'll just do a mistrial. I don't.
Well, it didn't get that. I mean, that essentially happened instantaneously.
Yeah, I mean, the ball didn't roll very far,
Right.
but the ball was kicked by the state. And that's the thing that I think prevents this from becoming manifest injustice, because the state can't cause a mistrial. And there may have been other factors here, but the main factor is that the state struck a juror because of that juror's race. That is the main problem here.
Well, except that, but for the overly aggressive jury coordinator, it wouldn't have been a problem. I mean, or it was a correctable problem.
And generally speaking, you take a Batson objections before the jury is sworn in. If the district court finds a Batson objection, valid, it can be addressed at that point. That's usually how it is. Here we have the jury coordinator stepping in too soon. But again, that's not on my client. My client is not directing the jury coordinator to do that. My client is not in charge of that courtroom. So even
No, but,
though,
I mean, it seems to me that the remedy here, so it seems somewhat gratuitous to me.
I would argue that the remedy is, as far as vacating the convictions, is the right remedy. We have double jeopardy protections for a very good reason, and that is to prevent excessive prosecution of defendants. We don't want, and we find it of value to prevent the state from trying again and again.
This was successful. He had to go through 2 voir dires.
It's
And that's about it. I mean, that's the success of
but-
this. But
And I would say that when we look at double jeopardy, we don't say, well, how far in the trial process did we get? Was it the first witness? Was it during closing arguments? The question is whether or not my client was put in jeopardy. And here he was. Once he's put in jeopardy, double jeopardy kicks in. So we have my client in jeopardy. The state caused this mistrial. It was their actions that were the triggering event. And they should not be able to then basically get around that by asking for a mistrial and getting to do it over again. I'll move to the first issue, which dealt with.
I don't recall seeing in the briefs anybody finding a case that is factually similar to this. I mean, I assume you did not locate something that is in that. I mean, it would be the rare critter, but
I did not find anything with this type of factual scenario where the jury was sworn in and then they addressed Batson objections. It is my legal career unicorn so far, and I did not find anything addressing this unique set of facts.
And I found one, counsel, I would have told you about it by now.
I appreciate that. I don't claim to be the best researcher, so I always take input from anywhere I can get it. But I certainly did not find anything along those lines. I think you are then going back to kind of the principles of double jeopardy.
Well, your client received the benefit of nullifying the error of the how the court handled the Batson procedure. He didn't have to go to trial with some juror that should have been excluded. Or was excluded incorrectly. Correct?
I will say sort of. My client does have a right, and this is part of the basis for Batson, to have a certain jury decide his case. And he did not get that here because a juror that should have been on that first jury was struck because of the juror's race. So I think to the extent he got a whole new jury, yeah, he did get that. But I still think there is a clear problem that, is the heart of Batson, that you can't strike a juror because of race. A defendant has that right to have that jury, assuming that juror who was struck because of a race was not.
It's actually, since he got the benefit of the Batson challenge, we are getting a brand new jury. The real question is that second jury an illegal double jeopardy, violation of double jeopardy? And that's the issue, isn't it?
Well, I think the declaration of a mistrial is the issue. I don't think the district court should have been able to declare a mistrial and bring it back for a new trial. I think double jeopardy steps in there.
What would you have had the court do? Go ahead and try the case?
No, I think the correct result is what we're asking for. That at that point, I think the district court should have dismissed the charges. And we're asking this court to vacate the convictions.
So in the first one, you're saying that the only correct, the first trial, the only correct results would be an immediate dismissal of all charges
Yes.
because
to retry my client, to go through a second trial would violate his double jeopardy rights.
was that ever argued to the district court?
I believe it was, and there was a habeas petition taken to this court.
That's true.
So that was well before the district court. There were motions after the mistrial was declared, and those were obviously denied.
And under our rules, I don't think that applies, is binding upon us, this panel.
Your order in that habeas?
Yes,
I don't believe it is either, Your Honor.
I think we take a fresh look at it.
Yes, I would agree with that, certainly. As far as moving to the first issue, couple points I would like to make about that. And first, as I've argued in my brief, I think the district court, and this is the issue that deals with the state improperly vouching for one of its key witnesses at trial. Both a witness vouched for one of the key witnesses, and then the prosecutor came back a couple pages in the transcript, came back a couple pages later and basically reiterated what the witness had said. Both were objected to. We think the district court, in this case, improperly denied my client's request for a mistrial. There are a couple reasons for that. Number one, I think the district court looked at the wrong things. As I pointed out in my brief, the district court looked at what were the old prosecutorial misconduct standards when we talk about gross and flagrant and ill will. And I think the problem with that is it took the court off of the issue it needed to look at, and whether or not these comments prejudiced the jury, prejudiced the proceedings such that my client could not get a fair trial. Instead, it was looking at the intent, and the district court specifically said it found, well, I don't think this was intentional. And that's not the point, because it's the impact that matters, not the intent behind these comments from the state. So we think the district court went along the wrong path when it looked at those issues. Secondarily,
What about the effect of didn't the judge say, jury disregard this?
the judge did, as far as the first, I think the first witness's comments, the judge just did say disregard.
Isn't that fairly prophylactic?
I don't believe it is, because I don't think there are certain things that just can't be unwrong. And when you have a witness, a key witness for the state, who makes very different statements about what happened. Some of
Talking
it,
about Pinnell?
yes, Ms. Pinnell, some of which supports my client's defense, self-defense, that this was a drug deal gone wrong. My client was in fact defending himself, then switches and says, well, no, we went there to rob the guy. My client, Ms. Pinnell said, my client brought a gun, pulled the gun. And that's when everything went bad. Those are very different stories. And when you have the state propping up one of them, namely that this was a robbery, I don't think that you can just expect the jury to disregard that by telling them to do so. And there's plenty of cases out there where improper comments have been made. District court says disregard that. And it's been found still to be reversible error.
Now, the second one, I think is interesting to me, because the judge sustained the objection, told the jury to disregard it,
Correct.
but then the prosecutor brought it up again.
That is true.
Tell me about that.
As I said, it's about a couple pages later in the transcript. I counted 7 questions later, and the prosecutor came back, because what the witness said was, from that point forward, I would say that she, Ms. Pinnell, was being what we believe to be fairly truthful with us. Prosecutor later came back and said, so you at some point, then you thought she was becoming more truthful in her statements. So the prosecutor is coming back and reiterating that point, that the statements that Ms. Pinnell made, that my client went there to rob this individual, my client pulled the gun, those statements were truthful. And I think bringing it up again has a cumulative effect here. Just the defense attorney at trial noted that and said, I had to get up again and object after the district court had earlier sustained my objection on the very same issue. And that brings it to the jury once again. And I think that adds to the prejudicial effect. And again, it's one of those things that you can't just wipe away with an instruction or with a district court saying, forget about it.
Counsel, I don't know how much time you have left, but I wanted to ask you a question about your second issue.
I was just gonna say, I'm gonna give you 1 more minute, because
Sure.
I know we haven't gotten to that second issue yet, so.
And that's the reputation
Yes.
evidence. What witness were you going to call?
Uh,
And what evidence was there about your client's reputation?
The witness that would have been called, a defense counsel believed it would have been a therapist from Burton Ash, a therapist familiar with Ms. Pennell and her treatment at Burton Ash. That's what she indicated to the court. And she believed that she could get a therapist who had a sufficient foundation, had sufficient information to discuss the reputation of Ms. Pennell as far as being dishonest and manipulative.
And was that witness called and the court says, no, you can't?
That witness was not called, and that was because of the court's order. Not only did the court release, originally, defense counsel had records custodian from Burton Ash there. This court released the records custodian because the district court did not believe that person could testify as far as reputation or opinion.
Well, the reason why I'm asking, I want to see if you preserve this issue for us to even review. And so I'm looking through the record, trying to see where you called the witness and the court turned you down. I couldn't find it.
No, that's not how it played out. The district court made rulings, as I said, the records custodian was there. The district court made rulings, released the record custodian, but also said that she did not see how my client could get anybody with the foundation to testify as to the reputation of Ms. Pennell. And I think when you look at the back and forth between trial counsel and the district court, it was clear the district court was ruling this isn't coming in, and that's how the trial counsel understood it. Trial counsel said
Thinking that's sufficient to preserve it.
I believe is. The issue was certainly brought up to the district court. The district court did make rulings, so I think it is properly before this court.
Right.
Thank you.
Good afternoon, Your Honors. I'm going to address the issues in kind of the same order that was previously argued, starting with the mistrial issue and the double jeopardy rights. So I think Judge Hill and Judge Atchison, you both pointed out the fact that this is essentially, well, if the court rules in favor of Mr. Hormell on this issue, it's essentially he's receiving two benefits here. He benefited from a new jury panel, and he would benefit from the convictions being vacated due to the double jeopardy issue. In the appellant's brief, it essentially tries to attribute this entire mistrial to the state. And while the state admittedly was the catalyst for this, just given the improper strike of a juror, the issue was undeniably compounded by the fact that Hormell and his counsel did not timely raise an objection on Batson grounds before the jury was sworn in.
Well, hang on. I looked at the transcript. There wasn't an opportunity.
I agree. There wasn't. And that goes to the manifest necessity here. The jury coordinator was the one primarily who messed up. The court never told him to swear in the jury. That being said,
He's a state actor, isn't he?
to the extent that the judge is, sure.
Well, so is the jury coordinator.
It's a state court.
I mean,
And that all
why
recognized,
isn't that attributable to the state as the prosecuting entity?
because
Divided out. I mean,
the reason for that would be, as Judge Huff, I believe it was Judge Huff ruled on this. Defense counsel had an opportunity to stop the swearing in. They knew of the Batson challenge. The state wasn't in that position. The jury coordinator wasn't in that position. Nobody knew about the Batson challenge except for Mr. Hormell and his defense counsel.
When did that become clear that there was going to be a Batson challenge?
My assumption is when they raised it to the court's attention, which would
At
have been,
that time,
there was
jury's already
essentially,
sworn in.
yes, and by that time, it's essentially, there's nothing that anyone can do to cure it other than a mistrial. The jury had been sworn in. We have ample case law telling us that if you're going to raise a Batson challenge, it has to be before the jury is sworn in. That didn't happen here. So essentially
it
what,
was raised at the earliest opportunity. That gets back to, I mean, I looked at the transcript and I've tried cases. I mean, the jury coordinator just the jurors were, the excused jurors were named and removed, and immediately the jury was sworn in. There was no opportunity at that point to do anything.
There would be,
Unless the defense lawyer got up in the middle of the swearing in of the jurors and said, wait, don't do that.
and essentially that's what Judge Huff said should have happened. And I would agree with that. If they know they have a Batson challenge and they see the jurors being sworn in, they have a duty to raise that challenge. Otherwise, it would be untimely. So it's essentially akin to a
Is it waived at that point?
I would argue it is. That being said, he still received the benefit of the mistrial. And
Whose rights are tied up in a Batson challenge? Who has rights affected by that?
that would be the defendant primarily.
Well, not exclusively, though.
I would say,
The juror also has rights too. right?
well, yes. The juror has the rights, but primarily the rights go towards the defendant because it's their right to a fair and impartial jury.
Well, no, I mean, I would disagree. If you read Batson, I mean, there is an equal protection right to serve on a jury, and you can't be excused because of your race. And I would suggest that that's an equally paramount protection and right. Which leads me to my question is, I'm not sure I see how the wrongfully excused jurors' rights are protected at all here.
I guess I'm not understanding exactly how that pertains specifically to this trial. I don't disagree with you. The dismissed juror does have equal protection rights involved in that. But as it pertains to whether or not jeopardy attaches to Mr. Hormell with regard to this mistrial, I don't believe would be entirely relevant to the discussion. Essentially, the state's position on this is Mr. Hormell and his defense counsel were at least partially responsible for the fact that a mistrial had to be declared. They could have stopped the swearing in. They could have stood up, raised their Batson challenge at any point before the jury was sworn in. And it had to be raised before the jury was sworn in. Otherwise, essentially, it would be waived. That being said, the court didn't find it was untimely, but found that it should have been raised earlier. So essentially, Mr. Hormell received the benefit from that mistrial. He got a new jury panel, a new jury trial, and now he wants another benefit again with his convictions being vacated at after the subsequent trial. Essentially seeking to benefit from a problem that he at least is partially culpable for. So
I take it you didn't find a case
I did not, Your Honor.
at all comparable to this.
No, this is a unique situation, to say the least. And
Hopefully it won't happen again.
that's usually the goal.
I mean, has somebody instructed this jury coordinator, don't be so quick?
Well, Judge Huff did say in the record that she was going to give him a stern talking to, so I'm hoping she did before she retired. So moving on to the next issue, whether or not the district court abused its discretion in denying his request for a mistrial. So obviously I'll address the elephant in the room first. It was error for the detective to testify as to the truth of another witness. I'll get that out of the way. And the prosecutor's subsequent reference to that testimony was also error. But the main focus here is not a perfect trial. It's a fair trial.
Does the judge's instruction to the jury to disregard it, does that have any effect at all, or is that useless?
I would say it does. So obviously we have longstanding case law saying jurors are presumed to follow the instructions that they're given. And here we have strong evidence that they did. So what happened is Mr. Hormell was also charged with conspiracy to commit aggravated robbery. Ms. Panel testified that she had pled to conspiracy for aggravated robbery in connection to this incident. But Mr. Hormel was acquitted of that charge. And that kind of tells us that the jury made their own credibility determination regardless. Because Ms. Panel testified that there was this whole conspiracy, that they had pre-planned this entire incident and that they were going to rob this man who just thought he was selling them marijuana. But the jury didn't believe that. They acquitted him of that charge. He was convicted of the aggravated robbery itself. However, we also heard testimony from the victim, who essentially testified he knew Mr. Hormel beforehand. He'd met him before, and that Mr. Hormel shot him. We heard testimony that he brought marijuana with him to sell to these two people, but that marijuana wasn't on him when he was found with a gunshot wound. Instead, that marijuana was found in Mr. Hormel's vehicle when he was pulled over a short time later. There's multiple witnesses to the shooting. Essentially, what I'm getting at is that the overwhelming evidence that was presented at trial supports the convictions that Mr. Hormel was convicted of. So essentially, to that extent, I would say that these improper comments by the detective and the prosecutor were pretty clearly harmless. And given that, well, just kind of back up a little bit, the question is whether or not there was a error in not granting Mr. Hormel's request for a mistrial. In the context of this entire trial, taken as a whole, the district court was correct in stating that there was ample evidence for the jury to consider in determining the credibility of Ms. Panel and the rest of the state's witnesses. And clearly the verdict shows that they did. They were instructed to disregard those statements. Again, the verdict shows that they did. And there's also the presumption that they follow the instructions that they're given. Mr. Hormel bears the burden of showing that the district court abused its discretion in denying his motion for a mistrial. And the state's position today is that he failed to meet that burden. Regardless of whether or not that was error, however, the record as a whole shows that it was harmless, as I previously mentioned. And so I want to make sure that I touch on the mental health records issue as well. Well, actually, before I move on to that, there was a point raised both in arguments today and in the reply brief. I think it was first raised in the reply brief of the appellant regarding self-defense. I would point out that self-defense isn't necessarily applicable under the circumstances. So Ms. Panel had two different accounts of what happened that day. One was true and one was false. Let's assume we don't know which was which. Both accounts say that this shooting occurred during a drug deal. Self-defense is not applicable to a drug deal. I'll just lay that out there right there. So I just ask that the court keep that in mind as well. So then moving on to the mental health records.
It's not in a.
Yes,
deal?
yes, Your Honor.
God, I would have thought that this day and age, self-defense applied in just about everything.
So
If I go to a drug deal and the other guy pulls out a gun and draws down on me, I can't pull out my gun and shoot him?
yes, Your Honor, that's essentially correct. KSA 215226A, that is the statute pertaining to self-defense when there's a forcible felony. The courts have interpreted drug transactions to be a forcible felony and therefore have found that.
The legislature knows about that. Fix that one.
No, it's been standing for decades at least.
Oh, well, there you are. See.
I believe a panel of this court just recently decided a case on it as well.
All right. I'm astounded.
So going to the mental health records issue, my position is largely the same as yours, Judge Hill, regarding preservation. There was a proffer. It was extremely vague.
Who was the witness?
A therapist from Burt Nash who is unknown,
Unknown,
unnamed.
unnamed.
We don't know whether or not they were the one who made any notes in that mental health record pertaining to Ms. Panel's alleged reputation for dishonesty and manipulation. We don't know how extensive their relationship with Ms. Panel is, so we don't know if they're even qualified to testify as to her relationship. We just don't know. And I think that goes towards the merits as well. Whether or not defense could even get a witness there for trial who is competent to testify as to this subject matter. We don't know. Originally, these mental health records, they tried to admit through a records custodian for Burt Nash. And for obvious reasons, that was denied by the district court.
Well, that's not the issue that we have. The issue before us is not Burt Nash records not being admitted. The issue that we have is bar reputation evidence.
Yes, and I think that goes back to my point is we don't know whether anyone that the defense could have put on to testify had any of the requisite knowledge to be able to testify as to Ms. Panel's character.
And we have to find that from our record.
Exactly. And I think that's my point is that we just don't have enough information. There's not enough information in the record to find that defense actually could have put a witness up there who was competent to testify as to the subject matter. And I'm not arguing that Ms. Panel's mental health or anything like that wasn't relevant, but everything needs to be placed in its proper context. So if we have someone go up there and testify essentially that, hey, this page of Ms. Panel's mental health records, there's a note on there that says she has a reputation for dishonesty and manipulation. We don't put it in context. My position is that it ceases to become relevant because there's no context to it. In what situation is she dishonest or manipulative? Is it just in a clinical psychological setting? Is it in her everyday life? We don't know.
1 minute, counsel.
And okay. And essentially, there's not enough in the record for us to figure out anything, whether or not they could have laid foundation, whether or not the witness would be competent to testify as to that subject. We just don't know. And today the state would just ask that issue, well, relief is denied as to that issue. And I believe the last issue here would be cumulative error. And I do want to address that briefly, just given the fact that I did say that there was error. So the prosecutor's statement and the detective's testimony, obviously those are two separate people. However, I would argue that given that the fact that they're the same thing, the prosecutor's subsequent comment was just referencing the detective's previous testimony that was stricken. Their close proximity in the course of trial, I would argue, is just one single error. And for that reason, well, cumulative error is not warranted, or I guess reversal on that cumulative error is not warranted when there's only one error in trial. And again, I'd like to, I guess, let the court dwell on this fact again. A criminal defendant is not entitled to a perfect trial. Personally, I don't think a perfect trial exists. But they are entitled to a fair trial. And that is exactly what Michael Hormell got here. And for those reasons, Your Honors, I would ask that this court affirm his convictions. Thank you.
I'd like to make just a couple of things. As far as the double jeopardy, it's been said a couple times now that my client received the benefit, right? But I would point out that the first trial was September of 2019. Because of the mistrial, he did not go to trial. And I understand COVID, right? He did not go to trial until April of 2021. He was incarcerated that entire time. So as far as the benefit of a mistrial, my client didn't get it. And he has a constitutional right, as I said earlier, to have a specific jury decide his case. That juror has a constitutional right to sit on that jury. Those are both violated in this instance. The other point I want to make is, as far as the harmlessness of the comments vouching for Ms. Pennell's statements, there is a harm here. My client was convicted of attempted voluntary manslaughter based on imperfect self-defense. The statements the state vouched for at trial painted my client as the initial aggressor, the individual going there to rob, the individual taking the gun with them, and the individual pulling out the gun. Jury was instructed as far as self-defense and initial aggressor. And they were putting their thumb on the scale by saying those statements are truthful. And the prosecutor coming back and asking that question, highlighting those statements are the truthful ones. So that did have an impact. And the only other thing I want to point out, as far as self-defense being applicable here, my client was charged with attempted second-degree murder. Self-defense is applicable to that type of charge. And here, those improper comments had an impact. And my client suffered the results, and we would ask this court to reverse for the reasons we have said in our brief.
Thank you. Thank you, counsel. Thanks for your arguments. We'll consider your case submitted for decision, and we'll get a written decision out as soon as possible. Okay. With that, court will stand in recess.